Welcome back, everyone, to the Law and Crime Network. I'm your host this afternoon, Caroline Polisi, on this very cold Friday afternoon here in New York City in our new studio. What do you think? I'm joined in studio today with Law and Crime's very own Misty Maris. Misty, thanks for being with us.
Thank you so much.
And Laura Nanos, thanks for coming in.
Thanks, this is awesome.
I know, it's great, right? So we're doing a special segment for our viewers today. It's called Ladies Who Law, and I'm going to get to that in just a second. But first I want to tell our viewers about a very special trial coming up. We're beginning to cover it on Monday. Jury selection begins on Monday. It's a death penalty case out of Florida. The case is against 49-year-old William Woodward, and prosecutors have charged Woodward with 2 counts of premeditated murder and 1 count of attempted premeditated murder stemming from an incident that occurred 5 years ago. Now, Woodward doesn't deny that he opened fire on 3 of his neighbors that evening, but he's claiming it's in self-defense. And because this case is out of Florida, of course, there are stand your ground law issues as well. Prosecutors, however, are describing this as a vigilante attack. They're saying this was not self-defense. This was not self-defense. Trial in that case could start as soon as Tuesday or Wednesday. We will be covering it here live on the network for you, gavel to gavel. You won't want to miss a second of it. And for now, I want to bring our guest back in. And you guys, it's great to have you here, not only because you are amazing attorneys and you know everything about the law inside and out, and your analysis is always spot on.
Absolutely everything.
But I mean, we're also friends, so it's kind of fun just to be able to talk law with your girlfriends. And so what I want to start with today, I think it's no surprise, we've covered the Me Too movement here a lot on the network. Of course, the Harvey Weinstein scandal, we even had Lisa Bloom on the network discussing when she was representing Harvey Weinstein at the time. But 2018 is here. 300 or more powerful women in Hollywood have decided that their resolution is that time is up, guys. So this new movement, Time's Up, it's sort of taking over the Twitter sphere, the blogosphere, and I just want to let our viewers know exactly what the movement entails. It's a legal defense fund, okay, backed by $13 million in donations to help less privileged women, and that's there are many more prongs, but I want to start with that aspect of it, Alora, because this incident, this movement started with very high-profile women, and so I think the issue is if you're not a Gwyneth Paltrow, if you're not a Rose McGowan, and you're experiencing harassment in the workplace, what can you do?
And that's why this is so important, because it can be very difficult to find anything to do because, as we all know, litigation's really expensive. And it's not just because lawyers are charging crazy fees, it's because even as a lawyer, litigation is expensive because it requires everything from filing fees to expert fees to investigation fees. It is just an expensive proposition. And what you will find is when you have plaintiffs in sexual harassment cases, other workplace violence or misconduct cases, if they don't stand to get millions of dollars, it can be very difficult for them to find an attorney who will take the case on a contingency fee, which means someone's got to fund the litigation. So what I love about this Time's Up movement is that it took Me Too, which was about sharing stories and bringing awareness, and turned it into something much more real with more teeth, where now it's saying, we're going to actually fund litigation. That's far beyond like, hey, tell your story on social media and raise awareness. That goes absolutely to the next level, which is exactly what this needed.
Yeah, and so Misty, Ashley Judd, Eva Longoria, America Ferrera, Natalie Portman, Rashida Jones. I mean, these are just a few of the many women actresses that are behind this movement, but there's also writers, directors in this field giving money to this defense fund. I even see that Tina Chen, who served as Michelle Obama's chief of staff, is also involved in the movement. What do you think this does sort of for the average woman out there trying to, get by?
Well, it's exactly what Alora was talking about, which is this part of the movement is more about prevention. It's more about awareness. Me Too really focused on exposing some of these issues, bringing forward these stories. Now it's, look, you actually have an avenue to pursue if this is happening to you. Don't be afraid. Just because you're not a multi-millionaire celebrity, you still have some sort of channel to go to. Now, again, litigation, it is expensive. Many plaintiffs' attorneys do take these cases on contingency fees, but guess what? They only get that money when the case settles, goes to trial, there's a judgment. Along the way, there's a lot of fees that could be thousands of dollars and could really be stifling to somebody that's looking to pursue a claim. Another thing that I think this brings attention to is the fact that many employers do have policies and procedures that are there specifically to protect the employees. Now, whether or not somebody sitting at their desk knows and understands that is another question. I go on a huge rant about making sure employers educate their employees on these policies, because there are employers out there who care. Right. It's not that every employer is looking to stifle claims. But you need to be able to understand that that's available to you, pursue it. And something like this fund is going to help both raise the awareness and give the ability to do that.
And it's really going to let it's going to take what Me Too was trying to do, which was to let women know, and by the way, not just women, but let victims know that they're not alone. And now it's basically taking that and saying, you're really not alone, because there's dollars there to stand next to you, and people, and lawyers, and organizations, and resources, which is, it really, truly much more meaningful in many ways than just, feeling like you're not alone.
Yeah. And maybe it's also not so scary to take that nosedive in, because don't forget, another part of litigation, set aside the cost, is the fact that you're going to have to sit there at a table. A deposition's going to be taken. Personal records, photographs, text messages, all that stuff is implicated in a lawsuit and becomes part of the litigation. That can be very daunting and scary to the average person.
Well, interesting you bring this up, because one of the other issues involved in this movement is an effort to bring about legislation that would penalize companies that tolerate persistent harassment, and discouraging the use of non-disclosure agreements that silence victims. So the point, Misty, you just made, of course, this could be an extremely embarrassing, humiliating event. It looks like you have something to say about it. Before we delve in, it's a rife issue, especially for attorneys, because look, on the surface of it, and I think Governor Cuomo just introduced legislation in New York to do away with these types of non-disclosure agreements in these types of cases. And it sounds great. It sounds great on the surface, but if you practice law like we do, you know that sometimes the women want non-disclosure agreements.
Exactly.
And so let's talk about it.
That is why I'm so torn on that issue. I understand maybe from a broad policy perspective why somebody would make that argument, especially now when one of the issues that's coming to the forefront is that many of these cases that were settled are subject to these non-disclosure agreements. It precludes women from coming forward, telling their stories, and all of that. But don't forget, when you are settling a case and you're agreeing upon those terms, that's a mutual agreement. It's a negotiable point of a settlement agreement. All that aside, forget the impact of that on the defense bar representing your clients, the ability to actually resolve cases pre-litigation. There are many people that come forward with these claims, the victims, that confidentiality is just as important to them as it is to the employer, because of all those issues that I just described, because many personal and private facts come out during the context of a litigation. That is the nature of it, because of the implications in a complaint, because of what that means to prove your case. So doing away with those non-disclosure agreements actually could be a disservice to some of the women who want to negotiate mutual non-disclosure, mutual confidentiality, mutual non-disparagement.
And I think that's very important as a point, because the larger kind of broader point about all of this is that workplace sexual harassment, or even sexual harassment outside the workplace, and sexual assault, they tend to function differently than other wrongdoing, other misconduct. There are issues that go with sexual misconduct that just play out differently in terms of how people act, what can be expected, how it affects people, how it impacts both the victim, and the accused. It is a unique issue, and I think that because of the uniqueness of it and what can be expected to grow out of it, sometimes what legislation, sometimes ideas about how to handle it are not going to work for sexual misconduct the way that they might work with other misconduct, because it just is different. And I think that the the easiest way to see that it's different is the issues with reporting. You don't see other harassment or other workplace incidents where there years, decades go by between the incident and the reporting. But you see that time and time again with any kind of sexual misconduct because it is a unique issue.
Right, and I think some, in terms of the broader implications of the non-disclosure agreement, one of the issues is the ethical boundaries of having a non-disclosure agreement, because sexual predators, as we know, are serial offenders. So if they are allowed to sort of cover this conduct up with nobody knowing it, and then they're continuing on in the workforce. The Harvey Weinstein issue is a great example. Misty is shaking her head. She has something to say.
I don't disagree
so
with you,
I
think that applies a little bit more in the context of an arbitration agreement. So just to explain to our viewers what the difference. So an arbitration would be a private proceeding. It's not going to be public in the same way that a lawsuit would be. Oftentimes, when you sign on with a company, part of that contract that you have or part of your employee manual offer letter might say that any disputes in the company will be resolved via arbitration. That sets right from the get-go that this is going to be a confidential process for both you and the employer. There's a difference when it comes to non-disclosure agreements and settlements.
People want to put those, do away with
yes,
those.
And I think
well,
that
right?
I think there's more of an argument in this context about making sure that companies aren't complicit in covering up misconduct. A stronger argument, not to say that I'm necessarily in support of that or not, when you're talking about arbitration agreements that you're entering into from the get-go with respect to sexual harassment, discrimination, Title VII, civil rights. Okay, so that's one aspect. The other aspect is the non-disclosure agreement that you would enter into in the context of a settlement agreement. And maybe this is what people need to know. It's a choice. When you're negotiating that settlement agreement, you can say, I don't want to settle the case. I would rather go to trial. I would rather have the ability to tell my story, and you can do that.
Right. It's not just the money that they're agreeing to. I mean, they're
agreeing to all these terms,
and all of them are important. And I think that,
and perhaps a fund like this, like we're talking about right here, helps you make that choice, because the daunting part of litigation is the expense, and that's for both the defendant. Don't forget, not every company is Harvey Weinstein.
Right.
A lot of companies, middle.
They don't even have it.
Companies,
they don't even have general counsel. Some of these companies, right?
Oftentimes. So it's really,
they're paying $500 an hour to even read the complaint, right? To even have a phone call with somebody. So no, I mean, really, at the end of the day, most people don't want litigation, defense or plaintiff, because it's so much to deal with. So I mean, my hope is that, not only do we have the fund existed before this Time's Up movement to help a number of other issues, and I think these kind of issues, and now we're getting these celebrities to just bring attention to it.
Right.
And I think that can never be a bad thing. We're seeing some male celebrities also get involved in this, which I think is incredibly important. I do a lot of work with students, with campus sexual assault issues, and I know that on campuses, while sexual assault against young men is underreported, the numbers are climbing because the climate in general is changing, and now we're seeing more and more and more reports, and the statistics are really sort of terrifying for everyone.
The statistics are, and they're tough, because when you're looking at those statistics in the context of a school, Title IX covers everything from something that you would be seen as less severe to something totally severe, and it's all lumped together. So it's difficult to really assess what's going on there, and thank goodness we have legislation and these laws in place to make sure that schools need to be transparent, and businesses, employers need to be transparent. One thing about the non-disclosure issue, and that you can kind of look as and maybe a template to see where this might go, is if you look at, and we're going to talk about this later, the Fair Labor Standards Act, which relates to wage and hour, which relates to proper payment, making sure everybody's making their overtime, their minimum wage, they're not being taken advantage of from a monetary perspective in the workplace. Those settlements have to be approved by a court. Right. Have to be filed publicly.
Hold that thought, Misty, because we are going to get there a little bit later. But you mentioned something else that I really want to talk about, and I'm not sure how much legal nuance there is here, but that's the issue. You said the word, it's being thrown around a lot, complicity. Okay, the issue of, we all heard the stories of the Weinstein Company about the honeypot sort of scenario whereby, this was an open secret in his company that many of his employers knew about. They would sort of invite a young female looking for a part to come meet with executives. That they would all sit there sort of giving a false sense of security, and then they would all leave and leave this woman alone with whom they knew someone to be a sexual perpetrator. So, obviously, since the Me Too movement, our issues of due process, our thoughts about due process are changing. We are choosing to believe the women in the first instance. We are not making them jump through these evidentiary hoops in order just to believe them. But the question is, what do you do as an employer? For example, we're also seeing a lot of, in the wake of this movement, we're seeing a lot of employers coming out saying, yeah, we had heard rumors, but they were everybody else was hiring them, and what were we really supposed to do? What does an employer do in that situation where there are these unverified, maybe unsubstantiated rumors, but yet they are faced with having heard them and thinking about what to do in terms of their company, their institution? How do they move forward in the face of that?
Employers, here's the thing, I think that when we're talking about things like litigation, like big, scary, big lawsuits, and it is so easy to look at an employer and say, well, it's too complicated to figure out what we should have done. How could we have prevented this? What training should we have had? But the bottom line is, the employer should use common sense. Now, is common sense gonna avoid every problem? No, it's not. There'll be times when they need a little more than that. But there are a lot of times, a lot of situations where basic carefulness would have saved an employer from liability. In the Weinstein situation, are you kidding me? I mean, seriously, if anyone in that company had operated with a modicum of common sense, things would have been completely different. And I think that employers just having the knowledge and the fear of the risk that these type of things pose to them, right, to just open your eyes, pay attention. Is everything that goes down on your watch going to be your fault? No, it's not. Is every person complaining telling the truth? No, they're not. But the employer has to have a basic awareness, by the way, not just of sexual misconduct, but of what is going on in their workplace in general.
Right.
So,
right.
I mean, paying attention is a good idea.
Yeah. And I think I just read something recently which I think made a really good point, is that, obviously the reason everybody was sort of covering up for Harvey Weinstein was that he was a rainmaker, right? They felt that he was sort of the economic backbone of this
company. And that's how
company.
It goes.
No, but now that calculation, that analysis is proving to be wrong. Look at the Weinstein Company. It's over. It's done now. Nobody wants to buy it. It's it's
and I think it's an example of, look, no one's untouchable. And this was finally exposed. Obviously, this is a very extreme example. You can find a lot more examples of something that maybe doesn't go quite that far. Weinstein's a unique situation because this man was just so outrageously
That's like
powerful.
One end of the spectrum.
Not just in his own company, but in this industry as a whole.
Right.
But the law has already accounted for a lot of this stuff.
That's right.
And the question is, how do you bring these issues to the forefront if you're not getting the complaints, if people do feel stifled? When you talk about employers' obligations, look, it's there. Outside of just the common sense, pay attention, you have an affirmative obligation as an employer that when somebody comes, or if you hear it, it doesn't even have to be a direct complaint. If you knew or should have known about the conduct,
you're supposed
and you're in a management position.
That's a great point, Misty, because all of these I didn't do it statements from these big companies, you can read between the lines. They are, there were no official complaints to HR. Well, that doesn't cut it.
It happens all the time. But guess what? If you're a management level employee and you see something happen, in some states, your knowledge is automatically imputed to the company. In other states, you're in a position where you knew or should have known about the conduct and should have reported it, and there's going to be consequences when it comes to a lawsuit.
Wow. And I think that point is why things like a public movement are so important. That is why Me Too is so important, because people naturally don't want to get involved. Right? That people don't want to get involved in reporting anything. People don't even want to get involved when it's something like child abuse. People don't even report it, right? So when it comes to like sexual misconduct in the workplace, no one wants to get involved. But when you have reframed the entire concept of it in the way that Me Too has, so that now someone who used to be perceived as a troublemaker now is reframed as some kind of a hero,
Yeah.
It changes
Yeah.
everything,
I just-
and that is
yeah.
so important.
It's true. And also just the knowledge. And I'll say, in the wake of the Me Too movement, and I'm just talking about a regional scale as a lawyer in New York who happens to do a lot of practice in this area, my phone rings off the hook with training for employers. And there's a lot of employers out there. It's not that they want to
Right, they don't
cover
want
up
these
this
things.
conduct.
They just
it's
don't
not
know
that
how
they're
to-
even
they
doing
just
it
don't-
just because
yeah.
they're scared of litigation. They want to have a safe and healthy workplace for all of their employees. They just don't necessarily know what the law requires.
Yeah.
And that's when you say, hey, call an attorney, call your general counsel. Really make sure your management level employees, and not just your Weinsteins, not just your C-suite, the people that are on the floor every single day interacting with the employers who are in the best position to know, have these obligations. If you're like third middle manager, you might not think, oh, this is really not my place.
Right.
Guess what? It is your
Right.
place. And if you find yourself in a situation where you did not properly report something, you could see yourself on the other side of a V in a lawsuit,
Yeah, that's true. And
as
in
a
years
complicit
past,
person.
like the average employer, you have your employees watch a video and click a couple of questions.
Yeah,
It's
make
like-
it interactive. I quiz them at the end.
I mean, really, that is never going to be the same thing as having a human being go into the workplace, get a vibe, come back and say, you got a lot of issues going on.
Right.
Let me go in there and actually talk to people about what is appropriate and what is not appropriate and what the law requires. And there's no substitute. There is no substitute for human interaction going in and really having a back and forth conversation with employees and managers about what is happening and what should be happening in any particular workplace.
Great points, you guys. We could talk about this
Forever.
forever. I could
Forever.
keep going. We are going to have some more segments in our Ladies Who Law special for you today. But right now, I want to take you back to some of the clips we were playing earlier with Jesse Weber of the Jessica Chambers trial. Remember, that is the trial against Quentin Tellis. Jessica Chambers' dying declaration was that it was an Eric or Derek who committed this crime. Well, that could be the reason that this trial ended up in a mistrial. We are expecting and anticipating that this trial, a new trial against Quentin Tellis for the murder of Jessica Chambers, will be sometime this year, which is why we are getting you caught up on the previous trial. So let's go back to that police interrogation.